Let's start by understanding that the declaratory rules, or Hukum Wadi, do not directly create obligations. Instead, they serve a different purpose. They help facilitate how obligation-creating rules operate, or they clarify the relationships between various obligation-creating rules. Think of them as guidelines that support the main rules rather than as rules that impose duties themselves. Now, when we look at classifications, the first major one involves secondary rules, which are divided into sabab, shart, and mani. These are crucial because they help us understand how obligations are triggered or conditioned. The usuli, or the legal theorist, focuses heavily on this classification to grasp how rules interact and depend on each other. Next, we have the classification into siha, butlan, and fasad, which relate to validity, nullity, and vitiation. This is particularly important for the faqih because it directly impacts how acts are performed, whether they are considered valid, void, or flawed. Finally, there's the division into azama and ruksa, meaning general rules and exceptions. This classification is a valuable tool for maintaining analytical consistency in applying Islamic law, helping us distinguish when strict rules apply and when exceptions are permissible. So, in essence, these classifications allow us to better understand the structure and application of obligations within the legal framework, ensuring clarity and precision in our legal reasoning. Let's take a closer look at sabab, which means cause. Sabab is essentially the reason or cause that triggers a primary rule or hukum taklifi. Think of it as the underlying factor that establishes whether a certain legal rule applies or not. In more technical terms, sabab is what the lawgiver has identified as the indicator of a legal rule. When this cause exists, it signifies that the rule is in effect. Conversely, if the cause is absent, then the rule does not apply. For example, unlawful sexual intercourse is a cause for the obligation of implementing had. That means if someone commits it, the cause is present, and the rule applies. On the other hand, safa and insanity are causes for interdiction. When these causes are present, the interdiction is in place. But if these causes are missing, then there is no obligation to impose had or interdiction. Understanding sabab helps us see how specific causes lead to particular legal obligations or prohibitions. It's a crucial concept because it connects the facts or conditions on the ground to the application of Islamic law. This way, we know exactly when a rule is triggered and when it's not, based on the presence or absence of these causes. Let's take a closer look at some key concepts: shart, mani, and mani. First, we'll focus on shart, which is essentially a condition. The lawgiver may specify that certain facts must be present or specific actions must be taken before a particular hukum or ruling can come into effect. These are what we call shart. It's important to understand that just because these facts exist, it doesn't automatically mean the hukum applies. However, if these facts are absent, then we know the hukum cannot be in effect. Moving on to mani, which refers to an obstacle. This is a factor that, when present, indicates the hukum or its cause should be negated. For example, the concept of negating retaliation if the accused is the father of the victim. The presence of this obstacle prevents the hukum from being applicable, even if the other conditions are met. Connecting these ideas, both shart and mani, help us understand the conditions and obstacles that influence whether a ruling applies or not. They are crucial in the process of determining the correct legal outcome, ensuring that rulings are fair and contextually appropriate within our overall legal framework. On this slide, we're exploring some important concepts related to acts in Islamic law: siha, fasad, and butlan. These terms help us understand the validity or invalidity of actions based on the lawgiver's requirements. An act that is obligatory, recommended, or even permissible must be performed in a certain way as prescribed by the lawgiver. If it's done correctly, it's considered valid or sahi. But if it's not done properly, it becomes null and void, which is called batil. Now, the Hanafi school adds an interesting layer here with a third category called fasid, meaning irregular or vitiated. An act classified as fasid can sometimes become valid if the cause of the irregularity is removed. If that cause can't be fixed, then the act remains suspended, but it might still have some legal effects. A good example of this is a contract involving riba or usury. Under Hanafi law, such a contract is considered fasid or vitiated. However, if the conditions that made it invalid, like the riba, are eliminated, then the contract could become valid. This framework helps us see how the validity of actions isn't always black and white, but often depends on specific conditions and the possibility of correction, which ties into our overall theme of understanding the nuances of Islamic law and its application. Today, I want to talk about a very important concept in Islamic law called azama and ruksa. The lawgiver, Allah, may initially set a rule that is considered an obligation, which we call azama. Think of azama as the general rule that applies in most situations. However, there are times when this general rule can be relaxed, and that's where ruksa comes in. Ruksa is an exemption or a concession that allows us to deviate from the general obligation under specific circumstances. For example, drinking wine is generally prohibited. It's haram for everyone. But if someone is in a situation of extreme necessity, like being on the brink of death from thirst, then they are allowed to drink it. This is a clear example of ruksa, an exemption granted due to a dire need. So, in summary, the lawgiver's approach often involves a general rule, but with flexible exceptions when circumstances demand them. This balance ensures that the law remains fair and compassionate, aligning with the overall principles of Islamic teachings. Let's explore the idea that Allah is the true source of all laws. In Islam, the fundamental principle is that Allah alone is the ultimate authority when it comes to law and guidance. You often hear the verse from the Quran, "The Hukum belongs to Allah alone," which is found in Surah 6, verse 57. This verse really emphasizes that all authority and decision-making in matters of law come directly from Allah. This core belief shapes how Islamic law is understood and interpreted. It guides scholars and believers alike in their approach to understanding what is right and just. When we talk about interpretation or ijtihad, we're essentially aligning our reasoning with this fundamental rule, acknowledging that Allah's guidance is supreme. For Muslims, surrendering their will to Allah means trusting that His laws are perfect and complete. It's about living life in accordance with His hukum, or divine command, because that's what leads to true guidance and fulfillment. And when we speak of the lawgiver, or hakim, it's important to recognize that Allah is the ultimate authority behind all laws. His role is central because everything is based on His divine wisdom and justice. This connection between Allah and law is what underpins the entire framework of Islamic jurisprudence and daily life. Let's talk about the core idea here, which is how the law aligns with the interests of humans. Essentially, the answer comes from the principle of istisla, or public interest, which aims to protect what we call maisali, that is, the benefits and interests that the legal system is designed to safeguard. Now, when there isn't a clear, explicit command in the Quran or Sunnah, our laws are then shaped by considering the broader interests of people, as determined by the lawgiver. This approach helps fill in gaps where direct evidence might not be available. Most jurists agree on this point, that the lawgiver creates laws with the well-being of humans in mind. But of course, there have been some differing voices. For instance, the renowned Imam al-Razi, who passed away in 606 AH, voiced some objections to this approach. So overall, this slide underscores that, although divine texts are primary, the legal system also considers the interests of humans when necessary. And this is a widely accepted principle in Islamic jurisprudence, even if some scholars have raised questions about it. Let's reflect on a profound question. Is man the sole purpose of creation? Or could it be that the universe was created for something even greater than man? This is a question that has intrigued thinkers and believers alike for centuries. Some might assume that humanity is the ultimate goal, but the Quran suggests otherwise. For example, in Surah An-Nazi'at, Allah asks, "Are ye the more difficult to create or the heaven above?" And then reminds us that Allah Himself constructed the heavens. This highlights a key point. The universe's creation is a deliberate act by Allah, and it points towards a purpose that might be beyond human understanding. It encourages us to think bigger. Perhaps our existence is part of a larger divine plan. As we continue through this presentation, keep in mind that understanding our purpose is linked to recognizing the grandeur of Allah's creation and His ultimate plan for the universe. Let's take a moment to reflect on the key points here. First, if man were the only purpose of creation, then logically, all laws would be designed solely to serve human interests. This view places humans at the center of everything. However, if we consider the possibility that the universe was created for a purpose beyond just man, something we can sense but not fully understand, then our role shifts. In that case, man becomes more like a worker or servant of Allah, what we call Abd Allah. This means our actions are judged based on our obedience and performance. We are to be rewarded if we do well and punished if we misbehave. But here's the crucial point. These ultimate answers about the true purpose of creation are known only to Allah. That's why, at the end of the day, jurists or scholars leave these questions unanswered, recognizing the limits of human knowledge. And I think it's important to remember that this perspective encourages humility. It reminds us that some questions are beyond our grasp, and ultimately, trust in Allah's knowledge and wisdom is essential. This fits into our broader theme, understanding our role in the universe and our relationship with the Creator. Now, let's consider whether we can employ maslaha, or interest, when deriving new laws. Most of the jurists agree that human interest can indeed play a role in the process of legal derivation. However, it's crucial to understand that this doesn't mean Muslims are free to create laws based solely on whatever they consider to be in their interest. The concept of interest here is carefully defined and limited. The key point is that the interest of man must be determined by the lawgiver himself, in this case, Allah, and there is a specific methodology for identifying what truly constitutes the interest. This ensures that laws remain divine in origin and are not subject to arbitrary human whims. Connecting this to our broader theme, it highlights the importance of divine guidance and the structured approach in Islamic law, especially when considering new issues or contemporary challenges. As we look at this slide, I want to emphasize the dedication of jurists in developing this methodology. They have put a lot of effort into ensuring that the law derived from it can still be recognized as part of the Ahkam of Allah, meaning it remains rooted in divine guidance. This highlights the careful balance they've maintained between human reasoning and divine law. Now, moving to the next point, it's important to understand that the future development of Islamic law significantly hinges on the doctrine of maslaha. This concept of public interest, or common good, is becoming increasingly vital because it allows us to adapt and interpret the law in ways that serve the broader community's needs without compromising core principles. Connecting this to our overall theme, it's clear that these efforts to refine methodology and incorporate principles like maslaha are essential for the ongoing evolution and relevance of Islamic law. They ensure that our legal frameworks remain dynamic and responsive to new challenges while staying true to their divine roots. Let's consider the relationship between the Sharia and natural law. As you can see, natural law has a very long and rich history, starting from ancient thought and continuing right up to today. It's a concept that has evolved over centuries and has been central to many philosophical and legal debates. When we talk about the classical theory of natural law, as Hart describes it, we're referring to the idea that there are certain fundamental principles of human conduct. These principles aren't just arbitrary, they are waiting to be discovered through human reason. And once we discover them, our laws and actions should conform to these principles to be considered valid. It's important to highlight that natural law has not always been directly associated with God. While some traditions link natural law to divine will, the core assumptions of natural law, like the existence of universal principles governing human behavior, don't necessarily depend on belief in God. Even when religious ideas are involved, natural law as a concept can stand independently of specific theological doctrines. So, in the context of our overall discussion, understanding that natural law isn't solely rooted in divine authority, opens up interesting questions about how it might align or conflict with the Sharia. Both systems seek to guide human conduct, but they do so from different foundations, one from divine revelation and the other from human reason and natural principles. There was complete agreement among the Muslim jurists about the meaning of the words of the Exalted. The Hukum belongs to Allah alone, which is from the Quran, chapter 6, verse 57. This statement emphasizes that ultimate authority in Islamic law rests solely with Allah. However, it's important to understand that this doesn't mean reason has no role in discovering Islamic laws. On the contrary, reasoning is a vital part of understanding and applying the principles of Islam. The key point is that all reasoning and logical deduction must be based on the foundational texts, the Quran and the Sunnah. These serve as the ultimate sources and guides for any reasoning process. So, while our intellect and reasoning are essential tools, they should always be aligned with and derived from these primary sources. This ensures that our interpretations and applications stay true to the core teachings of Islam. This balance between divine authority and human reasoning is central to how Islamic law is developed, and it ties into our overall theme of understanding the relationship between divine guidance and rational thought in Islam. Now, let's talk about the mahkum fee, which is essentially the act to which the hukum, meaning the ruling or command, is related. It's important to understand that the act here always refers to the actual behavior or action of the subject involved. When Allah's communication is related to this act through taklif, or obligation, it means that the communication creates a direct duty for the person to perform or avoid that act. In other words, it's a command that imposes a legal obligation on the subject. However, if the communication is related to the act through a declaration, which is a secondary rule rather than a direct command, then the act may or may not be the act of the subject. In this case, the link is not about obligation, but about declaring or establishing a rule that might influence the act indirectly. So, the key takeaway is that the mahkum fee is about the act that the hukum pertains to, and whether it's directly obligatory or just declared influences how we interpret the subject's involvement. This distinction helps us understand the nature of Islamic legal rulings and how they relate to human actions. Now, let's look at some key concepts about the obligations related to zakat. When there's a command to pay zakat, the obligation is directly linked to the act of the individual. In other words, it's about the person's responsibility to perform that act. However, when we talk about setting the minimum nisab, the threshold amount for zakat, the obligation shifts a bit. Here, we're dealing with a secondary rule or hukum wadi, which is more about making a declaration that supports the main obligation. It's like establishing the conditions under which the primary obligation becomes applicable. This brings us to how Muslim jurists analyze the concept of mahkum fee or the subject matter. They look at it from two angles. First, the conditions of taklif, meaning the conditions that make an obligation binding, and second, the nature of the act itself. Understanding these distinctions helps us grasp not just the legal requirements, but also the underlying principles that guide how obligations are structured in Islamic law. This is essential as we explore how these rules shape our responsibilities and the framework within which zakat is imposed. Let's talk about the condition for the creation of obligation, or taklif, as the jurists call it. They identified several key conditions that must be met for an obligation to actually come into existence. Essentially, a person only acquires an obligation and is placed under a duty when all these conditions are fulfilled. So, it's not just about having a duty in theory. There are specific requirements that make that duty legally valid and binding. Understanding these conditions helps us grasp how obligations are formed in Islamic law, which ties into our overall theme of understanding legal responsibilities and rights. When all these criteria are satisfied, we see the clear emergence of a legitimate obligation that the person is responsible for. All right, on this slide, we're focusing on two key conditions that are essential for understanding obligations. First, the act that is supposed to be performed or avoided must be known. This is crucial because the person involved needs to have a clear understanding of what the act is. The reason behind this is that they need to be able to conceive of the act in their mind and usually formulate an intention to perform it. Without knowing what the act is, there's no way for someone to consciously commit to doing or not doing it. The second condition is that the person should be capable of performing the act. The main goal here is to establish a command that actually obligates obedience. This involves two important subconditions. First, the act should not be impossible to perform. Obligations can't be about impossible tasks. And second, the performance of the act must depend on the will of the individual. In other words, they should have control over whether or not they carry out the act. If they don't have control, then it's not really an obligation in the true sense. These points tie back to our overall theme of understanding what makes an obligation valid and enforceable. It's about ensuring clarity and feasibility so that obligations are fair and meaningful. Today, we're going to explore the core concept of the nature of the act, or Hukum fi, as it's known in Islamic law. Essentially, the structure of Islamic law, how it's classified, and the obligations and duties that follow all revolve around a fundamental idea: rights. These rights are the foundation for understanding how laws are applied and how individuals are expected to behave within the Islamic framework. There are two main classifications of rights in Islamic law that we need to be aware of. The first is the right of Allah, or haq Allah. This encompasses our duties and obligations towards Allah, like worship, obedience, and fulfilling what He has prescribed for us. These rights highlight our relationship with the Creator and remind us of the divine expectations. The second classification is the right of the individual, or haq al-abd. This pertains to our interactions with other people, respecting their rights, fulfilling promises, and maintaining justice and fairness in society. Understanding these classifications helps us see that Islamic law isn't just about rules in isolation. It's about balancing our duties to Allah with our responsibilities toward fellow humans. Both are interconnected and form the core of a just and moral society. So, in essence, recognizing these rights and their classifications helps us grasp the broader picture of how Islamic law guides ethical behavior, promotes justice, and fosters community harmony. Let's take a moment to explore the concept of rights as presented here. First, we have the rights of Allah, which are often seen as being side by side with the rights of the individual. These rights can be categorized into two main types. The first type is where the right of Allah takes precedence, meaning that our duties to Allah are fundamental and often overarching. The second type is where the rights of the individual are more prominent, emphasizing personal freedoms and responsibilities. Understanding this balance is key, because it reflects the broader theme of justice and harmony in society. Moving on, we also see mention of the collective rights of individuals or the community, which are sometimes called haq al-sultana or haq al-sultan. These are rights that belong to the community as a whole, not just to individuals. They highlight the importance of social cohesion and the responsibilities we share for maintaining order and justice within the society. In essence, this slide underscores the importance of balancing individual rights with collective rights, and how these concepts are rooted in our understanding of divine and social responsibilities. It's a reminder that justice involves both respecting personal freedoms and upholding the collective good, which is central to the overall theme of ethical governance and community harmony. Let's take a closer look at the classification of duties, the original and the substitutory. As we discussed earlier, every right we have is paired with a corresponding duty. Essentially, a right is protected or secured when the person who owes the duty actually performs the required act. In other words, the duty must be fulfilled for the right to be realized. Muslim jurists have a specific way of understanding these duties. They distinguish between the original form, which they call asl, and the substitutory form, known as khalaf. This distinction helps us understand the different ways duties can be fulfilled or replaced. Understanding this classification is important because it connects directly to how obligations and rights function in our legal and social frameworks. It emphasizes that fulfilling duties is essential for securing rights, and that there are different forms or approaches to fulfilling those duties. By grasping these concepts, we see the underlying structure of how duties support rights, which is central to the overall theme of our presentation: how legal obligations maintain social harmony and justice. Let's take a closer look at this slide. As an example, it mentions that the performance of prayer is a duty that stems from a right of Allah, meaning it's something Allah requires from us. Now, the key point here is that this duty isn't just a suggestion. It's a responsibility that we owe to Allah because of His rights. Next, the slide highlights that the condition for performing prayer involves ablution, or wudu, which must be done with water. When this act is performed with water, it becomes wajib, or obligatory. So, performing wudu properly is not just a ritual, it's a mandatory step to ensure the prayer is valid. And what happens if someone cannot find water? The lawgiver, in his wisdom, provides a substitute: clean soil. This shows the flexibility and practicality in Islamic law, making sure that even in difficult circumstances, the essential act of purification can still be fulfilled in a permissible way. Overall, this slide emphasizes the importance of understanding both the spiritual obligation and the practical means of fulfilling it, connecting to our broader theme of understanding how Islamic duties are rooted in divine rights and practical considerations. Now, let's talk about the importance of classification in Islamic criminal law. Muslim jurists categorize crimes based on which right has been violated. This classification is not just a theoretical exercise, it has a direct impact on the procedures used in court. For example, when the right of Allah is violated, the procedures we follow are known as hudud and qisas. These are specific, divinely prescribed punishments that reflect the severity of violating God's rights. On the other hand, if the violation involves the rights of an individual, the procedure is called ta'zir. An important aspect here is the evidence required, which typically involves the testimony of 2 women for every man. This shows how evidentiary standards are tailored to protect individual rights. Finally, when the crime involves the rights of the state, the procedure followed is called siyasa. This classification and the associated procedures help ensure that justice is administered appropriately, respecting the nature of the right that was violated. This classification system underscores how Islamic law integrates principles of justice and procedural fairness, aligning the punishment with the specific context of the violation. Let's take a closer look at this classification and how it influences legal rules and distinctions. When we talk about commuting a sentence or granting a pardon, the key point to remember is the nature of the offense and who it affects. For offenses against the right of Allah, the rules are quite strict. Once a person is apprehended and convicted, the penalty cannot be waived or commuted. This reflects the divine nature of these offenses. There's a sense that they are beyond human discretion once proven. On the other hand, for offenses against the right of an individual, or even against the state, the situation is different. In these cases, the penalty can be commuted or pardoned. This gives the state some flexibility in administering justice, allowing for mercy or other considerations to come into play. It's also important to note that the state can pardon any sentence that is not a had. Since had penalties are considered the right of Allah, they are not subject to pardon or commutation. But for other types of sentences, those that are not classified as had, the state has the authority to pardon or commute. This distinction underscores the idea that certain punishments are divine prescribed rights, and others are more flexible, giving the state the ability to exercise mercy where appropriate. This concept ties back to the overall theme of balancing divine justice with human discretion within our legal framework. On this slide, we're discussing the concept of shubhat, or mistakes, in the context of hudud. When we talk about shubha, or doubt, in the right of Allah, it has a specific effect. It waives the penalty of had. Essentially, if there's any doubt about the act being a clear violation of hudud, that penalty doesn't apply. However, it's important to note that the same doesn't hold true for ta'zir, which are discretionary punishments. In those cases, doubts don't necessarily waive the penalty. Another key point here is qisas, or retaliation. It's considered part of the right of Allah, and because of the presence of shubha, qisas can also be waived. This shows how shubha impacts the application of certain penalties in Islamic law. Overall, Islamic law doesn't oppose this approach because establishing guilt beyond doubt is a fundamental requirement. If there's any uncertainty, the law tends to favor caution, which underscores the importance of clarity and certainty in legal judgments. This connects to our broader theme of justice and precision in Islamic legal processes. Let's take a closer look at the concepts of shubha and tazir. As we examine this slide, it's important to understand that all tazir, meaning the discretionary punishment or authority, belongs to the individual. This is a fundamental principle, and because of this, the concept of shubha or doubt does not really apply when it comes to tazir. This view is supported by Al-Kasani, who clearly states that tazir is a matter of individual right. Now, some jurists, mainly from the Shafi'i school, have taken a slightly different stance. They suggest that tazir can also be considered a right of Allah. However, this is where things get a bit inconsistent. If tazir were indeed a right of Allah, it would prevent the possibility of pardon or forgiveness, what we call afwa. But as we know, afwa is an acknowledged attribute of Allah, and it actually complements the concept of tazir. So the key takeaway here is that the majority view emphasizes individual authority in tazir, and associating it directly with Allah's rights introduces some contradictions, especially considering the role of pardon. This discussion ties back to our overall theme of understanding the balance between divine authority and human discretion in Islamic law. Let's take a closer look at slide 27. Here, we're exploring the nuances of criminal proceedings and evidence within this context. One key point is that the admissibility of women's evidence varies depending on the type of case. For example, in cases related to Allah or hudud, a woman's evidence is not considered admissible. However, in cases involving individual rights or tazir, women's evidence can be accepted. It's important to note that when it comes to women's testimony, the requirement of one man and two women still applies to maintain balance in evidence standards. Now, moving on, there's a significant distinction when it comes to the rights of the state. No such restrictions apply here, meaning a single woman's testimony can be valid in cases falling under siyasa or state affairs. Circumstantial evidence is also admissible whenever the issue concerns haq al-sultana or the right of the authority. The overall takeaway is that criminal proceedings and the evidentiary requirements are not static. They change depending on the right involved. This highlights the flexibility and context-specific nature of legal processes, which is an important aspect of understanding how justice is administered within this framework. Let's explore how human rights fit into the broader framework of Islamic law by looking at the classification of maqasid al-sharia, or the purposes of Islamic law. This classification is divided into public and private interests. Essentially, it helps us understand what benefits or protections are prioritized within the legal system. From this division, we can see how certain human rights are recognized and upheld according to Islamic principles. These rights are not arbitrary. They are derived from the core objectives of the law itself, aiming to preserve faith, life, intellect, lineage, and property. So this classification isn't just an abstract concept. It directly influences how human rights are understood and implemented within the framework of Islamic law, tying the overall theme of justice and ethics together. Let's look at this slide and break down some key ideas. First, it highlights that in Islamic law, whenever someone is in court to claim that a duty has been breached, a correlative right is also present. This means that rights and duties are closely linked. If there's a duty, there's a corresponding right. Next, it emphasizes a crucial point. As long as there is someone who can enforce the performance of a duty, a right exists. And importantly, this right actually resides in the power or authority of the person who is able to enforce it. So, the enforcement capability essentially defines who holds the right. Finally, we see that the idea of rights within Islamic law clearly includes this enforcement function. Since the legal system's primary role is to adjudicate or settle rights and duties, it becomes necessary to have someone who can claim or enforce those rights. This connection between enforcement and rights is fundamental to understanding how Islamic law structures rights and duties within society. Let's take a closer look at the analysis of rights. The term right in everyday language, or even in a broader sense, actually covers several concepts. These include claims, liabilities, powers, and immunities. Now, it's important to understand that among these, only the word claim truly captures the meaning of a right in the strict legal sense. At other times, when we talk about rights, we're really referring to the liberty to act or not to act, the freedom to do something or refrain from doing it. This kind of understanding has led to what is known as the Hofeldian scheme, which is a way of analyzing rights and duties more precisely. Now, connecting this to Islamic law, if we apply this kind of analytical scheme to the concept of rights within an Islamic legal framework, it could really help us better understand the nature of jural relations, how rights and duties interact within that system. Gaining this clarity would, in turn, lead to more accurate and just adjudication of rights in Islamic law. This slide underscores the importance of nuanced analysis when we're trying to understand rights in a comprehensive way, which is essential for the overall theme of our presentation, building a deeper, more precise grasp of legal concepts across different systems. Today, I want to talk about the nature of duties in Islamic law. A duty, in simple terms, is an obligation to do something. But what's interesting is how we can view this concept from different angles. It's more helpful to think of a duty in terms of performance, meaning what we are actually expected to do. This perspective focuses on the action itself. On the other hand, obligation can also be seen from the angle of acceptance and imposition, how it's imposed on us and our acceptance of that. So the key point here is that viewing duties as performance emphasizes the active side, what's required of us, while obligations highlight the authority or command behind it. This distinction is important because it helps us better understand how Islamic law guides our actions, by emphasizing the duties we perform rather than just the obligations we accept. In the context of our overall discussion, recognizing this difference helps us appreciate the practical aspect of Islamic duties, how they shape our behavior and moral responsibilities. Let's delve into the difference between natural rights and rights given by the law. Natural rights are inherent to us. They exist simply because we are human. These are rights that don't depend on laws or governments. They are fundamental to our existence. On the other hand, rights given by the law are bestowed by legal systems or authorities, and they can also be taken away or modified by those same systems. Here's a key point. Both of these types of rights are distinct from the rights granted and taken away by the state in a more limited regulatory sense. When it comes to rights granted by the Sharia, for example, these are seen as divine and inherently protected. The state's role in such rights is minimal. They can only be taken away if the Sharia itself allows it. This highlights an important concept: the role of divine or religious law in defining and protecting rights, which can differ significantly from secular legal systems. And this distinction is crucial because it shapes how we view authority and the protection of individual rights within different frameworks, tying into the broader themes of justice and governance we've been exploring. Let's break down this slide. First, we see the symbol Copyright 2020 by Continuous Learning Development, which indicates the source. Now, onto the main content. The concept of he is the person whose act invokes a hukum, or a hukum requires him to act in a prescribed manner. Essentially, this means that certain actions or behaviors trigger specific legal rulings or commands. In legal language, this individual is known as the mukallaf, which translates to the subject. This is the person who is responsible for fulfilling or adhering to these legal obligations. A key point here is that a mukallaf must have legal capacity. This means they can act either directly, by themselves, or through delegated authority, like an agent or representative. Now, the first requirement for someone to have this legal capacity is the ability to understand the communication that creates the obligation. This understanding can come directly or through a knowledgeable person, such as a mujtahid or faqih, who explains or clarifies the legal ruling. To summarize, the subject, or mukallaf, is essentially the person responsible for legal duties, and having the capacity to understand these duties is fundamental. This ties into the broader theme of understanding responsibility and accountability within our legal and ethical framework. So, in addition to the basic requirements for someone to be subject to the law, there are other important conditions that must be met. These are related to legal capacity, which in juristic terms is called aliyah. Essentially, this refers to a person's ability to understand and engage in legal acts. This concept is crucial for grasping the broader framework of Islamic law, but it takes on particular significance when we look at criminal law and contract law. After all, for someone to be held accountable or to enter into valid agreements, they need to have the appropriate legal capacity. Understanding aliyah helps us see how the law differentiates between those who can and cannot be responsible or legally effective in their actions. It's a foundational concept that connects deeply with the overall structure of Islamic legal principles. Let's start by understanding the core idea behind aliyah, or legal capacity. The term literally means absolute fitness or ability. Basically, it refers to a person's capacity to acquire rights and exercise them, as well as to accept duties and perform them. Now, this capacity is generally divided into two types. The first is aliyat al-wujub, which is the capacity for acquisition. This means that a person has the ability to obtain rights and obligations, so they can own property or enter into contracts. The second type is aliyat al-ada, or the capacity for execution. This is about actually exercising those rights and fulfilling those duties. For example, when someone signs a contract or makes a legal agreement, they are exercising their capacity for execution. Both of these capacities are essential for understanding how individuals interact within the legal system. They form the foundation of legal personality, allowing a person to be recognized as a rights holder and duty bearer. Throughout this presentation, we've been exploring how legal capacity relates to the broader theme of legal responsibilities and rights. Recognizing these two types of capacity helps us understand the scope of a person's legal abilities and limitations. Let's explore the concept of dhimma a bit more deeply. Some jurists believe that the term dhimma also encompasses the ability to acquire rights and obligations. So, it's not just a passive concept, but something that reflects a person's capacity to engage legally. Think of dhimma as a kind of balance sheet for a person, showing their assets and liabilities, but in terms of rights and obligations. It's a way of understanding what a person is entitled to and what they're responsible for. Now, when we look at it from a Western legal perspective, the term dhimma aligns closely with the idea of personality. This refers to the attributes conferred on both natural persons, like us, and artificial persons, such as corporations. So, whether we're talking about individual humans or legal entities, the concept of dhimma helps us understand their legal standing and responsibilities. It's a foundational idea that ties into the broader theme of legal capacity and rights within different legal systems. Let's explore the underlying bases of legal capacity. The first point to understand is the manat, or the basis, for the existence of capacity for acquisition. This is rooted in the attribute of being a human or a natural person, which we call insaniya. Essentially, every human being inherently possesses this capacity, regardless of whether they are legally accountable or mukallaf. Now, moving on to the capacity for execution. The manat here is different. It's primarily based on aql, or intellect, and rushd, which we can think of as discretion or maturity. When we talk about aql, we're referring to the full development of mental faculties. But here's the interesting part. There's no single definitive way to measure whether someone's intellect is fully developed. So, the lawgiver has linked this to bulugh, or puberty, because reaching puberty is a clear milestone indicating mental and physical maturity. So, to sum up, the capacity for acquiring rights is an inherent human trait, while the capacity to act upon those rights depends on mental development and maturity, often marked by puberty. This distinction is crucial because it helps us understand how different aspects of capacity are grounded in both natural attributes and developmental milestones. This slide highlights the concept of capacity, which is essentially about a person's ability to engage in different kinds of acts under the law. It's divided into three main types, based on the kind of liability involved. First, we have the capacity for the kitab jinai, or legal capacity for criminal liability. This relates to the communication or acts that involve criminal behavior, where the law recognizes a person's responsibility. Next, there's the capacity for the kitab of ibadat, which is the legal capacity concerning acts of worship. This is about how the lawgiver communicates rules and obligations related to religious acts, like prayer, fasting, or other forms of worship, where understanding and intent are key. Finally, we have the capacity for the kitab of muamalat, or legal capacity for transactions. This covers the legal communication related to transactions and commercial acts, like buying, selling, or contracts, where the law defines the responsibilities and rights of the parties involved. Understanding these distinctions is crucial because they help us see how the law interacts differently depending on the nature of the act, whether it's criminal, religious, or transactional. This classification ensures that legal capacity is appropriately aligned with the specific liability and context involved in each act. Let's talk about the concept of legal capacity as it's understood by Muslim jurists. They divide it into three main types: kamila, nakasa, and kasara. Today, we'll focus on kamila, which means complete capacity. First, complete capacity for acquisition refers to a person's ability to gain rights and obligations. This capacity is present after birth, meaning that once someone is born, they are eligible to acquire various rights and responsibilities under the law. Next, complete capacity for execution involves a person's ability to carry out actions, essentially, to implement or execute their rights. This is established when a person reaches full mental development and gains the ability to discriminate between right and wrong, or between beneficial and harmful actions. And here's an important point. This stage of mental maturity is often associated with and externally marked by puberty. So, in a nutshell, we see that legal capacity develops as a person matures, starting from birth and reaching full expression with mental development and puberty. This understanding helps us grasp how legal responsibilities and rights are assigned within Islamic law, aligning maturity with the ability to understand and act appropriately. Attaining bulug, or puberty, by itself is an important milestone, but it's not the whole story. What really completes a person's capacity for action is something called rushd, discrimination or maturity in their actions. This means that reaching puberty isn't enough. They also need to demonstrate a level of judgment and understanding. The evidence for this is found in the Quran, specifically in the verse that talks about testing orphans until they reach the age of marriage. It emphasizes that once they reach this age and show judgment, their property should be returned to them, but with care, warning against wastefulness or rushing their development. So when someone attains full capacity, that is, both bulug and rushd, they come under the scope of all different kinds of kitab, or legal communication. This highlights how important it is to recognize not just physical maturity, but also spiritual and intellectual maturity in our responsibilities towards individuals. Let's take a closer look at the stages leading to full legal capacity, as outlined by the Hanafi jurists. The first stage begins from birth and lasts until the child reaches what is called partial discretion, which is typically around the age of 7. During this period, the child is considered too young to be assigned the capacity to perform legal acts or make binding decisions. Essentially, they aren't yet capable of understanding or bearing legal responsibility. Moving on to the second stage, this starts from age 7 and continues until the child hits puberty, or reaches the legal age of puberty if that happens earlier. In this stage, the child is generally seen as having deficient capacity for execution. That means they can sometimes perform certain acts that are legally recognized, but their capacity isn't fully developed yet. This gradual process helps us understand how legal responsibility matures over time, aligning with the overall development of the individual. Now, moving on to the final stage, which begins either at the onset of physical puberty or when a person reaches the legal age, whichever happens first. This stage is crucial because it marks a point where the individual is fully recognized as capable of making independent decisions. At this point, they are assigned complete capacity for execution, meaning they can undertake actions and responsibilities on their own. They also become eligible for each kind of kitab, which refers to different types of legal and social responsibilities or communications. It's important to note that attaining this stage isn't just about puberty. Rushed or maturity is a key condition here. So even if someone has reached puberty physically, they also need to demonstrate mental and moral maturity, rushed, to fully enter this stage. This ensures that they are truly prepared to handle the responsibilities that come with full capacity. Overall, this stage signifies a transition into legal and social independence, provided both puberty and rushed are established. It's a vital part of the overall development process, aligning physical growth with mental readiness to engage responsibly within society. Today, I want to talk about two important concepts related to capacity: deficient and imperfect capacity. Deficient capacity occurs when the manat, or the mental state required for legal acts, isn't fully developed. This means the individual might not have the necessary mental faculties to understand or perform certain legal actions properly. On the other hand, imperfect capacity is a bit more nuanced. It's when the person does have a basis of capacity, meaning they are human and possess discretion, but something external has been introduced that affects the validity of their acts. In such cases, an external attribute, like coercion or fraud, prevents us from recognizing the legal validity of certain acts. Understanding these distinctions is crucial because it helps us determine when a person's capacity is genuinely lacking, or when external factors are influencing the legality of their actions, which ties directly into our broader discussion on legal capacity and its limitations. Let's talk about some cases of deficient legal capacity, starting with the unborn child, or Janin. When we say that the Janin has deficient capacity, it means that it can have some rights recognized, but it doesn't bear obligations like an adult would. Essentially, certain rights are established for the Janin, but it's not fully capable of managing obligations on its own. This happens because the Janin is considered part of the mother in some respects. It's not seen as an independent person yet, so we don't assign it a fully independent personality. Instead, it's closely linked to the mother during this stage. However, despite this deficient capacity, the Janin does acquire some specific rights. These include protections like freedom from slavery and rights related to inheritance, bequests, and percentage shares. These rights are established to safeguard the child's interests even before birth, recognizing its potential future personhood. So the key takeaway here is that the law recognizes the unborn child as having certain rights, but not full legal capacity, because it's still considered part of the mother. This approach balances the child's emerging interests with the legal reality of its current state. Now, let's talk about minors and their legal capacities. A child, or minor, has the full ability to acquire rights and obligations, which means they can own property or enter into contracts. However, even though they can hold these rights, they lack the capacity for execution until they reach the age of actual or legal puberty. Essentially, they can't independently carry out actions that require legal responsibility until that point. This concept also applies to individuals who are considered mata, or foolish, meaning they lack mental capacity. They cannot be held criminally liable for their actions, as their mental state prevents full responsibility. Despite this, minors are still subject to ta'dib, or discipline. This discipline is meant to guide and correct them, recognizing their growing understanding and the need to teach them proper behavior. So, in summary, while minors have rights, their ability to execute those rights is limited until they reach a certain age, and their mental capacity also affects their legal responsibilities. All of this ties back to the overall theme of understanding different levels of capacity within the legal framework. Let's take a moment to consider what it means when we say that a dead person has a deficient capacity for acquisition. What we're really saying is that once someone has passed away, they can no longer acquire or accumulate anything new. This idea might seem intuitive, but it's important because it affects how we handle their debts and obligations. For example, amounts due on account debts, bequests, and funeral expenses are all taken from the wealth of the deceased. Essentially, their estate is used to settle these obligations. This reflects the principle that the deceased's wealth is responsible for their debts, not the living. Understanding this helps us see the broader picture of estate management and the importance of properly settling what's owed before distributing the remaining assets. It ties into our overall theme of how we handle wealth and obligations after death, ensuring that debts are paid and the estate is settled fairly. Let's discuss some cases of imperfect legal capacity. Historically, this concept has been attributed to women and slaves. When we talk about the legal capacity of a woman, it's important to understand that she is considered to possess imperfect legal capacity. This means that, in some contexts, her ability to act legally is limited. Specifically, some hold the view that women should not have the right to undertake certain duties, especially those involving divine rights or obligations. Moving on to slaves, the situation is a bit different but equally significant. A slave does not have the right of ownership, meaning they cannot own property or possessions outright. However, they do have the capacity to acquire obligations related to acts of worship, or ibadat, and they can also be held accountable for criminal offenses. These distinctions help us understand the historical and legal context of how capacity has been viewed and assigned. Recognizing these limitations is crucial for a comprehensive understanding of legal responsibilities and rights within different societal structures. Now, let's look at the natural causes of deficient capacity. These are factors that are beyond the control of the individual, or mukallaf, and they stem from acts of the lawgiver and creator. These causes are considered involuntary and are recognized by jurists as impacting legal capacity. There are 10 main causes listed under this category. First is sayar, which refers to minority or being underage. Next is junun, meaning insanity, which affects one's mental state. Then there is ada or foolishness, which can impair understanding. Nisyan or forgetfulness also plays a role, especially in recalling obligations. Wam or sleep temporarily takes away awareness. Igma, including unconsciousness, fainting, or epilepsy, can also render someone temporarily unable to act legally. Another cause is rik, which refers to slavery. Historically, this affected legal capacity. Marad, or illness, can diminish a person's capacity temporarily or permanently. Haid, the menstrual period, and nifas, the postnatal bleeding, are natural biological states that influence legal responsibilities. Lastly, maut, or death, obviously terminates legal capacity altogether. These causes highlight that some aspects of capacity are naturally outside a person's control, and understanding them helps us grasp the broader context of legal responsibilities and limitations. Now, let's look at the acquired causes of deficient capacity. These are causes that are created by humans or are influenced by human actions and choices. Essentially, they are factors resulting from human will or decision-making. Muslim jurists have identified 7 key causes in this category. The first is ignorance, or jahl, which refers to a lack of knowledge or awareness that can impair someone's capacity. Then there's intoxication, or sukar, which occurs when a person is under the influence of alcohol or drugs, affecting their judgment. Next is jest, or hazal, meaning acting playfully or lightly, which can sometimes lead to a loss of seriousness in important matters. Indiscretion, Safa refers to acting impulsively or without proper caution, which can also diminish capacity. Journey, or safar, is another cause. Being away from familiar environments or under travel conditions can impact one's mental state and decision-making ability. Mistake, khata or shuba, involves errors or misunderstandings, often arising from confusion or misjudgment. Lastly, coercion, ikra, occurs when a person is forced or compelled against their will, which can impair their capacity to act freely. All these factors underscore how human actions, whether through ignorance, influence, or pressure, can lead to a temporary or situational deficiency in capacity. Recognizing these causes helps us understand the importance of deliberate, informed, and voluntary actions within the framework of justice and responsibility. This ties back to our overall theme, understanding the nature of capacity and the factors that can impair it, whether inherently or through external influences.